So, good afternoon, everyone. Welcome back to our weekly webinar series. Today, we are taking up a very relevant topic for all of us. That is, how do you verify or verification of claims under IBC, whether it is the CIRP process or the liquidation process, and the importance of the various judicial pronouncements, the various disciplinary orders from IBBI, and the proposed changes in the claim verification process. We will discuss all that. It might take more than 1 hour, so we will be open to make this two-session topic, but it's a topic of importance, and let's take it forward and let's start. Over to Anil, sir.
Thank you, Ankit. Namaste to all participants. As we always say that I see your large participation gives us motivation, and every week our participation is increasing. The registrations are increasing, and I am very happy to announce that today our registrations are more than 500. So that gives us pleasure, and that gives us motivation to work hard. This particular subject, verification of claims under IBC, this has already been presented once by Ankit before the ICMA webinars. And however, our legal team, which consists of Shalya Agarwal and Amar Vivek, and all these are lawyers, so they have also worked very hard on finding the various judgments. So the flow of this subject, as the subject is very large, there are a lot of litigations on claims. However, we have the kind of flow that we have now we will do. One is that we few couple of definitions which are very important. Then what are the sections and regulations? Then the claim form, like few minutes on these things. Then when we verify claims, then section 53 is very important. And for each claim that we verify, we actually have to assign a clause of section 53 for each claim. Then only the information memorandum and the resolution plan can be prepared. Challenges that we receive in claim verification, and then we have bifurcated the various judicial pronouncements. One is the claims before the approval of the resolution plan. Maybe it is belated claim or some of the other issues in the claims. Then there is other categories that when we try to resolve a dispute about claims where the resolution plan has already been approved. Then other things that we have noticed in claim verification, that the stage of the CIRP is very important. When we see the various judicial pronouncements, we have seen that the judicial pronouncements are somehow depending upon the stage of the CIRP. And it is not based on the 90 days or the claim verification period. It is based on the status of the CIRP. Then the judicial pronouncements are different for home buyers. It is different for operational creditors. Even the judicial pronouncements are different for statutory liabilities. For workmen, it is entirely different. Operational creditors, it's different. We also have seen of late that the recovery certificates or the arbitration awards, these are also considered. Ankit has rightly said that in the disciplinary orders issued by IBBI, there are some concept that it is very important for all the professionals to know. Proposed changes are also very important. So going forward, let's now start, because this is our analysis is that there is no straight line when we say verification of claim. There is no straight line when we say that the belated claims are rejected by the adjudicating authority, belated claims are accepted by the adjudicating authority. So the various factors that the adjudicating authority might have considered while accepting or rejecting, how much, like various factors are, how it is impacting the resolution plan, how it is impacting the process, how it is impacting the society, how it is impacting the home buyers, how it is impacting the workers. So these are various considerations when we see adjudicating authority resolving an issue regarding claims. So Ankit, actually this is the this analysis that we are trying to do is very important, because see, there are to my understanding there are something like 50-60 judicial pronouncements that we have analyzed, all on claim verification. But the kind of crux that we have found, there is no straight line, and it keeps moving. It is changing. That line is also changing as we receive some Supreme Court judgment regarding workmen, or we have now a Supreme Court judgment on recovery certificates. Then we also may have some amendments in the regulations, and some amendment in the some kind of order from IBBI on disciplinary. So the process is changing. It is not static since the last 5.5 years. Let's see the first of all the very important word in our definition under section 3 subsection 6, which actually defines claims. See, very important word which is used in both clause A and clause B is a right to payment. Right to payment in clause A is also used, and in clause B is also used. And in case you see right to payment, now whether such right is reduced to judgment, fixed, disputed, undisputed, legal, equitable, secured or unsecured, but then the right of payment is common for all. If there is a right of payment, whether the particular claim is reduced to a judgment, like the kind of recovery certificate or the kind of the arbitration awards, and fixed, whether the right of payment is fixed or it is variable or it is disputed, undisputed, legal. So then in case you see the second as subsection B, right to remedy for breach of contract under any law for the time being in force, if such breach gives rise to a right to payment. Now, think of a situation where the home buyers, they have a right to remedy, because in case they don't get possession in within the stipulated time, then they have a right to remedy, and that right to remedy is right to payment, because they have a right to get their money back. Whether or not such right is again reduced to judgment, fixed, matured, unmatured, disputed, undisputed. So for a right to payment is one is a transaction. The second is right to payment out of a breach of contract. So these are two clauses which are very important. And in case the right of payment is missing, it doesn't mean that it's a claim. The right of payment is very important. So section 18, subsection 1, clause B says that it is the duty of the IRP, RP to receive and collate all the claims submitted by the creditors pursuant to public announcement made under section 13 and 15. Section 15, subsection 1, clause C of the code, and along with the regulation, it provides that the claims are to be submitted within 14 days of the appointment of IRP. Then regulation 12, subregulation B, subregulation 2 of CIRP regulation provides that the creditor who fails to submit claims within 14 days can submit the claim on or before the 90th day of the insolvency commencement date. So these are the forms that we use for submission of claims. One important change, that one important difference that you would see for a financial creditor are, it is mandatory for them to submit their claims in electronic form. For financial creditors, it is mandatory for them to submit their claims in electronic form, because they have to form committee of creditors. So that this dispute would be, because in case they submit it in electronic form, then it is evident that the claims are submitted electronically and there is a proof. So therefore, there is no space for any dispute as regards constitution of COC. Therefore, the claim from a financial creditor has to be mandatorily in electronic form, so that it leaves evidence when the claim was submitted. However, in operational creditors, workmen and employees, authorized representative of workmen and employee, claim by others, they can submit in person, by post or electronic, whatever they feel like. Now, why section 53 that we have reproduced here or we are presenting here? It is very important that we try to understand when we verify the claim, first of all, the insolvency resolution process cost and liquidation cost. This has to be separately admitted, and saying that this is got a priority treatment and this claim is being admitted under subsection under clause A of subsection 1. Then when we admit the claims of workmen, then we have to segregate the workman dues, one for 24 months preceding the liquidation commencement date or the CIRP commencement date, and others. Others means that in case it is beyond 24 months, then it will go to clause F, and in case up to 24 months, it will go to clause B1, B subclause 1. So therefore, the wages and employees, when we come to clause C, if it is for 12 months, it will come under subclause C, and in case it is beyond 12 months, it will be admitted under clause F. So while admitting the claims, it is very, very important that we should also specify the clause under which your claim is admitted. So for any residual claim beyond 24 months or even beyond 12 months, it will fall under clause F. Now coming to this clause, subclause E, the following dues shall rank equally between and amongst the following. Clause subclause 1 says any amount due to the central government and the state government, including the amount to be received on account of the consolidated fund of India and the consolidated fund of a state, if any, in respect of the whole or any part of the period of 2 years preceding the liquidation commencement date. So in case there is a claim of income tax department or GST department, in case the claim pertains to 2 years preceding the liquidation commencement date or 2 years preceding the CIRP, then it should be separated, and up to 2 years it should be admitted in this clause E subclause 1, and rest or the remaining should be admitted in clause F, because the clause F is a residual clause, and this clause F is also for the operational creditors. So this concept that I wanted to say, that while admitting the claims, it is very important to understand and provide while admitting that which particular clause your claim is being admitted. So as far as this part is concerned, the verification is as the collation and verification, there are two, a little bit of not 100% clear, because the act says that we are supposed to collate and the regulation says that the RP is supposed to verify the claims. And all these documents like records available with information utility and other relevant documents, contract for supply of goods and supply of corporate, so invoice demanding payment, financial contract supporting the financial statement, documentary evidence demanding satisfaction of claims, proof of employment for the purpose of employees and workmen, bank statements in case the money is received or not for the satisfaction, any order of the court or any tribunal, all this is required to be submitted, and IRP or RP has the power to ask for additional document, and that will be provided by the creditor claimant.
So before we move further, we can take two small questions. One
and
question
also
is,
this okay, practical difficulties in any case will take up. See, you can yes, let us take up the questions.
So one question is that is it mandatory for the IRP to verify a claim from the information utility registered with IPBI? So I believe yes, the IP is supposed to log into the IU and see what all claims are already available on the IU. And that also gives information on maybe possible claims which somebody has not filed and seeking or asking them to file the claims, because as per the draft regulations also, the expectation now is that the RP will look into the books of accounts and other sources and invite claims from those people who may not have filed their claims.
Also, there is a recent requirement that for Section 7 applications, the IU, the claim must have been uploaded on IU, and a copy of that proof of transaction recorded on IU is required to be submitted along with any application under Section 7. That has been stipulated. So that is one document which is mandatory now. Yes, I think you're right, because see, now of late, in case we see the judicial pronouncement, we have seen that the responsibilities of IRP and RP is increasing based on various judicial pronouncements. For example, number one, when it comes to the claim from workmen and employees, the judicial pronouncements are saying that even if the workmen or employees have not submitted their claims, it is the duty of the RP to look into the books of account, find out the liabilities regarding the workmen and employees, provide that information in the information memorandum, which is prepared by the RP, so that the resolution applicant should provide for this liability. Similarly, for statutory liabilities, the judicial pronouncements are saying that the RP should look into the books of account, and based on the books of account, these liabilities should become part of the information memorandum, and the resolution applicant should provide for this. For home buyers also, similar expectation is from the RP, that the RP will look into the books of account of the corporate debtor. Based on the books of account, all the liabilities, all the home buyers, all the advances received from the home buyers should become the part of the information memorandum. And even if the claims are not filed by the home buyers, the resolution applicant should consider all the liabilities as per the books of account. So these are various examples where I'm saying that the books of accounts are very important, even if the claims are filed or not filed. Suppose there is a class of creditors like debenture. Now, the judicial pronouncements are saying that the debentures, the list of debentures are more importantly available with the corporate debtor or with the registrars of transfer. So they would provide us the best information regarding any debt, which is a class of creditor, rather than seeking claims. So this is a kind of obligation that is now being put on the RP, that all these information should be collated from the books of account, provided in the IM, so that it is provided in the resolution plan, so that later on, by all these parties, the claimants should not come that my claim is not being considered, my liability is not being considered. So whatever is provided in the IM approved by this COC and adjudicating authority, that would be final, even if the claim is not filed or filed. So this is something which is an additional duty. Belated claims, we have a lot of litigation on belated claims, where the claim amount is not precise. That also we have the various judicial pronouncement, unmatured claims, non-cooperation from promoter is something which are challenges that we have, because in case the books of accounts are not available, it is difficult for us to verify the books of account and provide the information in the IM. So, so this is Ankit, something which
So
are
let
practical
me
difficulties.
so
Yes.
let me take some more questions.
Yes.
And one question coming in is that home buyers, in case they have a registered builder buyer agreement, and in case the other buyers might just have allotment letters. So I believe they will always be filing their claim as a financial creditor, and as like that's how the status will be as a claimant. I think this question is coming in from the Section 53 discussion that we were having.
So Section 53, one, that the home buyers are unsecured financial creditors as per Section 5, subsection 8 and clause F. This particular clause F says that any amount of advance given for any future transaction of purchase or sale, that would be considered as financial debt. So according to my understanding, any advance which is given for future purchase or sale, that should be a financial debt. However, some controversial judgments, including one of the judgments from Supreme Court, where it has been considered as operational creditors. However, the home buyer, specifically this particular section, has been added an explanation where the allottee, as per the definition of RERA, has been considered as financial creditors, and that too unsecured financial creditors. So the allotment letter or BBA agreement, the most important part is that the amount has been paid by the creditor, and even if he doesn't have the BBA agreement, but the allotment letter and thereafter the payment, that is something which is important to establish a person as allottee under RERA and then as a financial creditor under IBC. Yes, Ankit.
Then we have a question from Mr. Srinivasa Reddy. He is asking whether genuinity of documents to be verified by RP and IRP.
No, the judicial pronouncements are saying that it is the duty of the RP to see trueness of the claim and the genuineness of the documents, but the RP is not supposed to adjudicate the disputed claims. RP will simply see. So this is a right of payment as claimed by one person, and that right of payment should be admitted in case the documents are matching, in case the documents are complete, or the RP should issue a deficiency letter and seek more documents.
So then we have this opinion from an anonymous attendee that most of the operational creditors are reluctant to provide financial statements with claim documents. However, regulations require to provide financial statements. There has to be, if regulations require financial statements to be provided, and then
no, I don't think I don't think for operational creditor the financial statements are not required by the claimant. However, their bank statement is required, because in the bank statement the RP will see whether this amount has been received by them or not. But I have not seen that the financial creditors operational creditors are supposed to submit their financial statements for the
many
purpose
operational
of claim
creditors may not even have any financial statements.
Yes, that is not the requirement according to my reading of the regulations and section. There is no requirement of submission of financial statements by an operational creditor along with the claim documents. Yes, Ankit.
Then there are many other practical questions. I think we can take these up after some time. These are all timing related, which are part of our presentation. Maybe after some time we can take more questions.
So you see, you can take up these judgments in case you, because these are basically judgments where the belated claims are filed before the approval of resolution plans by adjudicating authority. So this is one category that we have collated together, and where the belated claims are filed during CIRP and where before the approval of the resolution plan by the adjudicating authority. I think you can take up some of these the judicial pronouncements.
So this one is a 2019 judgment, a fairly old one, and it is basically one of the standard setting judgments that had come in. This one is from NCLT Mumbai. It says that it was held in this judgment Ramakant Suryanath Pandey versus CS Prakash K. Pandya, that the scope of a resolution professional is limited to verifying the claims received in light of Regulation 13 and 14 of the BBI CIRP regulations. And the resolution professional is not an adjudicating authority and is not required to inquire into the factual scenario between parties and determine their rights and liabilities. The task of the RP is to limit itself to confirm that the claims received by him are true and correct. Verification is a process of establishing truth, accuracy, or validity of the claim. It is not meant to be passing of a judgment or making a decision on the quantum of claim. So this is in line with what was also held in the Swiss Ribbons case, that is the famous Supreme Court judgment, which says that there is a differentiation between the claim filing and the claim verification process with the IIP or with an IRP or an RP versus a liquidator.
So this is also the answer to the question that one participant was asking.
The genuineness of the documents is the duty of the RP. But yes, in case the RP receives the documents and there is a dispute or amount of claim is pending because of some dispute, there the court says that you are not supposed to adjudicate that dispute. You
So
can't become.
establishing truth, accuracy, or validity of the claim is what is the name of the process called verification.
Yes.
Yes, yes, Ankit.
Then before this one is GPR Power Solutions Private Limited versus Supriyo Chaudhary RP of Rohit Ferrotech Limited. It was held in this case that creditor's claim could not be rejected by resolution professional as time barred if filed within extended deadline granted suo motu by Supreme Court due to COVID-19 lockdown. This is a 29/11/21 judgment. So any claim from that COVID related period that was, universal, that COVID exemptions were available to everyone. So those timelines, this was extended because of that. This one is Synergy Technologies versus Parthiv Parekh, resolution professional of Sangvi Forgings and Engineering Limited. Again, a 2022 judgment, recent one from April, an NCLAT judgment. It was held that where appellant filed its claim as unsecured financial creditor, but same was not considered by COC and NCLT while approving resolution plan, financial creditors who received major chunk from resolution applicant should refund original claim minus any amount received by the financial creditor. So
This is a
basically,
landmark. This is a
yes,
landmark. This is
yes.
something which is which
So in
must be
case, so
discussed.
in
Yeah.
case some claimant filed their claim, duly filed their claim, maybe that person never received any response from the RP or the office of the RP. The resolution process gets passed, the resolution plan gets passed, the RP completes the process, and later it is found that, oh, this claim is left out of the IM, out of the entire process, but it was filed accurately. Now, this is a judgment which establishes that you can't just remove that judgment out of the entire process. Now, it makes it a liability that you take the money from all the people who got money through the resolution process and give that money to this person who had filed their claim.
So
So,
this is a landmark because even all the RP has to be very careful that in case any claim is received, that is considered. If it is not considered, that may even disturb the resolution plan later on. Yes, Ankit.
So then we have Sumit Kumar Gupta, RP of Vallabh Textiles Company Limited versus Vardaman Industries Limited. In this case, this is again an inclined judgment, very recent one, 27 July 2022. The facts here were that the resolution professional rejected the claim of the FC on the following grounds. He said the claim was not filed on basis of old authorization. The claim should have been filed through the resolution professional. The account statement attached to the claim was not sufficient to authenticate the claim amount, and the claim submitted by FC was already rejected earlier. He cannot file a belated claim again. So issues in this case were whether an RP is competent to decide or reject the claims of financial creditor by himself without presenting the complete facts before COC on the admission of the claims.
So I think this is the very because this is still continuing. The Sumant Kumar Gupta is continuing. This is a very important and clear judgment where the role and duties of the RP is defined after even kind of uh, acknowledging the Swiss ribbon, where it has been held by Honorable Supreme Court that the resolution professional has no adjudicatory power, and that he is really a facilitator of resolution process whose administrative functions are overseen by the COC and by the adjudicating authority. So this judgment from NCLAT, it establishes again that the RP should not simply reject a claim in case the claim has been received, although whatever the law says very clearly that a claim verification is an independent process which is supposed to be done by RP. The COC has no role in claim verification, but this judgment says that without even discussing with the COC, the RP should not have rejected the claim. So this is the only judgment that we see where the COC has also been seen as having some role in claim verification, in acceptance or rejection of the claims. Otherwise, in no other judgment we have seen that the COC is also supposed to be discussed or supposed to be consulted before rejecting or accepting a claim. So this again a kind of mind changing, process changing judgment, we have not found any such regulation or any section where the claim verification, rejection or acceptance is also subject to the approval of committee of creditors. That has not been seen by us, but this is the first judgment on this, and we are not sure whether this particular, it has gone for appeal before Supreme Court or not. Yes, Ankit.
So, in that judgment, to read the final number, so of course that judgment kind of concluded that you have to present it before COC. So I think the whole essence is that in case you have a belated claim, you have a disputed claim, you have to put that information in front of everyone, and the RP's duty is limited to verifying that the supporting documents are there and the claim is actually a real one. Then this one is the Deputy Commissioner Division 7 Central GST versus Kiran Shah RP of Vickers Stainless Private Limited. And then this one, it was held that this is again NCLAT judgment. The resolution professional was not duty bound to create claims which are belatedly received after the last date, thereby delaying the entire CIRP, which is time bound process, and further having regard to the fact that the claim of the appellant was incorporated in the information memorandum which was circulated to prospective resolution applicant and the members of the committee of creditors for their consideration. There is no dereliction of duty on behalf of the IRP RP as provided for under sections 18 and 21 of the code. So in this case, this was where the GST department had filed a belated claim. The RP had incorporated that belated claim in the IM and had not processed the claim and admitted the claim. So here when the department, GST department went up to NCLAT and said that our claim should be accepted, that was then rejected. Mukul Kumar, RP of KST Infrastructure Limited versus RPS Infrastructure Limited. In this one, again, an NCLAT judgment, very recent, like a year back. Here it says that it said that under regulations 8, 12, 12.2 and 13 of the code, it is apparent that the IRP RP can accept the claim as per extended period as provided under regulation 12.2. It means after extended period of 90 days of CIRP date, the IRP RP is not obliged to accept claim. There is no ratio of the judgment that the regulations are directory and not mandatory. With the aforesaid, we are of the view that whenever any claim is filed after the extended period provided in regulation 12.2 of the regulations, the RP should have rejected the claim. The regulation has not provided any discretion to RP for admitting the claim after the extended period.
Now, this is again something which is in various other cases where the home buyers have been filing their claims belatedly. It has been directed to the resolution professionals in many cases that you accept this claim. Now, in case the intent of the adjudicating authority is adopted by the RP and RP accepts the claim, which is a belated claim, just to avoid litigation, just to avoid cost. And that is something where the RP should not be reprimanded. But we have not seen any such order where the RP has been reprimanded because the belated claim has been accepted by the RP. Because the RP can do this in view of avoiding litigation, saving litigation cost, and also kind of expediting the process. Otherwise, such litigation can delay the resolution process. So according to my understanding, in case it is not disturbing the process, the RP can admit a claim which has been submitted belatedly. So this, of course, this is an NCLAT judgment, but according to our understanding, we still feel that the RP should accept, considering that the process has to be completed in a time-bound manner.
This one is R. Natarajan versus Radhakrishnan Dharmarajan RP of Appu Hotels Limited, NCLT Chennai bench judgment dated July 21. Here it was held that belated claim cannot be condoned and accepted at belated stage, especially when the resolution plan is approved by COC and is pending before NCLT. So this is something that we will see even in further cases where the stage of CIRP is at an advanced stage, especially where the resolution plan is approved by the COC and pending before the NCLT, and somebody just wakes up at that point in time and says that, oh, my claim is pending and my claim is a major claim or a minor claim, doesn't matter, but my claim is pending and I was not made part of this entire resolution plan. So there are plenty of judgments now, which we will see later, which also say that no, you can't just derail the whole process once the resolution plan is approved by the COC and pending before NCLT for the tribunal's approval. The contrary opinion in case of Edelweiss Asset Reconstruction Company versus Edel Landmarks is an NCLT principal judgment. It is held that the rejection of claim on ground of delay is not sustainable because the provision has been held to be directory. So it was made clear that all resolution professionals shall make a note of these repeated orders passed by NCLT, clarifying that amount of an applicant, claim of an applicant, home buyer like the present one, could not be rejected on the ground on delay as the provision has been held to be directory. So here again, it was a home buyer matter, and maybe a few claims had come in later. We will
So
discuss them.
this is where I said that the adjudicating authority has been passing orders. One, as you rightly said, based on the stage of the process, also based on the claimant. If a claimant is a home buyer, I don't think, because there is any court in India who would say there are 10 home buyers and they have paid 50 lakhs each for acquiring a property, for acquiring a home, and if there is a court which says that now all that 50 lakhs rupees that you paid to the builder is all vanished, I think that's very difficult for any court to decide, even if
Yeah. So
even
we'll
if it,
see. So
yeah.
we'll see in judgment. I think this one or there's another judgment now which kind of gives home buyers some rights or kind of says that they should get something or they should be talked about, because so these judgments envisage that there'll be some home buyer who has missed the bus, who is not claimed, who is not part of the whole CRP process. If you find out later that such a person does exist and that person needs claim needs to be addressed, then how will you do that? So that's an important issue that has been taken up. I think after approval of resolution plan by AA, this NCLAT judgment, Delhi judgment, recent judgment in June 22, says that where appellant home buyers had booked their flats with corporate debtor, a real estate company had filed their claims before RP after resolution plan was duly approved by COC, they could not have been included in the list of creditors. So it says that yes, they can't be included in the list of creditors. Then it says that where appellant home buyers who had booked their flats with corporate debtor, a real estate company filed their claims before RP after the resolution plan was duly approved by the COC, appellant's claim was not extinguished, as extinguishment of claim of appellant would happen only after the approval of plan by AA. So it says that when they filed a claim after the resolution plan was approved by the COC, their claim will not go to the list of creditors perhaps, but their claim is not extinguished yet because our resolution plan is not approved by the AA. Then it says where applicant home buyers had booked their flats with corporate debtor and made payment and their claims were reflected in records of the corporate debtor, same ought to have been included in the information memorandum, and resolution applicant ought to have taken note of such liabilities and should have appropriately dealt with them in the resolution plan. And therefore, resolution applicant was directed to prepare addendum to resolution plan by including claims of such home buyers. So this is the judgment, which is a landmark judgment, that in case of home buyers, if somebody comes in later and says that, oh, I missed the bus, but I have paid this much amount, he has been given relief even where the resolution plan was pending for approval before the AA.
So this is where I said that the adjudicating authority is passing orders, and it all depends upon the claimant, the nature of claimant, the category of claimant, and the stage of the plan. So going forward now,
It also depends on facts of the case. So in this same case, say let's say in Puneet Kaur versus this developer case, say the RP would have say evidence that he invited those people who he found in the books of accounts to submit their claims based on the email addresses available with the developer. That would then lead to a different conclusion.
I think that's where the present discussion papers are proposing.
Yeah.
The discussion papers are proposing that it is the responsibility of the RP to communicate with each liability which is appearing in the books of account, and to communicate and understand whether the claims are filed or not. That is also an additional liability which is there in the proposed regulations, which we are waiting after the discussion papers. So, and now I think since we have now touched that particular where the approval of the resolution plan by adjudicating authority, that is again the stage. Now let us understand, even the last case was also after the approval. So what we are doing in most of the real estate cases, that we are asking the resolution applicant to provide a paragraph in the resolution plan how those claimants would be dealt with who have failed to file their claim. And in most of the resolution plans, we are saying that it is mandatory to insert a clause in the resolution plan that anyone who has not submitted their claim, they would be entitled to submit their claim within 6 months of the approval of the resolution plan by adjudicating authority. And that would be considered as per paragraph number so and so of the resolution plan. So in this manner, it also gives a resolution for all the claimants who actually approach adjudicating authority along with the resolution plan, who failed to submit the resolution plan and their claim has not been considered in the resolution plan. So that gives a resolution in case the plan provide for such people. I will just go to this ADS Resources Limited versus Shilpi Cables Technologies Limited, April 22 judgment, where it has been held that if an operational creditor failed to file their claim during CIRP and filed its claim only after public announcement by the liquidator, appellant had failed to file the claim within stipulated time, and resolution being a time-bound proceeding, the appellant could not seek realization of its claim amount at such belated stage. So this is something which is for an operational creditor. Earlier judgment that we have seen, that was for a home buyer. The home buyer, it was a different judgment. For an operational creditor, it's a different judgment. Similarly, for this Ruchi Soya Industries Limited, ETC versus Union of India, again, this is a Supreme Court judgment, and it said once a resolution plan was approved by the adjudicating authority, all claims as provided in the resolution plan would freeze, and all such claims which were not a part of the resolution plan would not survive. This is a Supreme Court judgment in Ruchi Soya Industries. And another judgment in the Supreme Court, other judgment of NCLAT, and that's again June 22, it's Ruchi Soya Industries versus Joint Commissioner of Labor and Class Cess Assessment Office. In this case, the resolution plan was approved. All claim which has not been filed by the CIRP are not part of the resolution plan, stands extinguished. So therefore, the Joint Commissioner of Labor demanded labor cess on the construction work undertaken by the appellant. However, it was neither pressed any claim nor issued any demand notice. Therefore, it stands extinguished because the resolution plan has been approved by the adjudicating authority. Similarly, another NCLAT judgment, Damodar Valley Corporation versus Kharkia Steel Private Limited, it's March 22, where liabilities of appellant related to pre-CIRP dues which had been extinguished, treatment of past dues of appellant in approved resolution plan was in accordance with the legal provisions of IBC. Therefore, appellant's claim of adjudicating past electricity dues could not be upheld. So as we have seen the labor commissioner, we have seen the demand from an electricity authority, we have seen the operational creditor, we have seen home buyer. All these cases are after the approval of the resolution plan, and you have seen, and in the case of electricity dues, not acceptable. In the case of labor commissioner, not acceptable. In the case of operational creditor, not acceptable. However, in the case of a home buyer, it is the duty of the RP to provide it in the information memorandum, and it is the duty of the RA to again consider that. So we can take up any questions, Ankit, because I can see
So
there
these judgments which we're talking about are also judgments which are addressing basically two issues. One is the claim issue, that whether any claim is valid. These are also judgments which are basically trying to block the resolution applicant from reviving the company by using some old dues. So actually these are all, two purpose, or rather having two meanings, the judgments, all the ones that we're looking at, where they're coming in, or these people are coming in and filing their claims or saying that this debt is not extinguished post the resolution plan is approved.
I
So
think there are
there are
two, no, Ankit, there are 2, 3 more judgments, similar judgment like this Ghanshyam Mishra and Sons Private Limited versus Edelweiss Asset Reconstruction Company, April 21, very popular judgment, where it is very clearly said by Supreme Court that the claims of the respondent prior to the approval of plan cannot be continued. I mean, this is again similarly like the Hydra had popping up every day, which was used in the Supreme Swiss ribbon. Once the resolution applicant is successfully taking over a company, and later on new claims are coming every day, that was called by the Supreme Court as Hydra had popping up, and every day, so that will not be considered as a clean slate. Equally, the claims which are not part of the resolution plan shall stand extinguished. Thus, on the date of the approval of the resolution plan by the adjudicating authority, all claims which are not part of the resolution plan shall stand extinguished. Similarly, Principal Director General of Income Tax versus Synergies Dure Automotive Limited, again unclad judgment in March 19. Once the resolution plan is approved, it shall be final and not subject to modification, even if statutory claims are not included in the plan. So these are similar judgments that we are saying after the approval of the resolution plans, uh, rather than it's like kind of we have seen this workers, it is a duty to be provided in the IM, home buyer, but for everything else, once the resolution plan is approved, it is actually kind of extinguishing all claims. I think we can take up some questions at this stage, Ankit.
So we have many questions, so let's try and give brief answers to all the questions for which maybe we have talked about things, and for the ones that are part of our presentation, we can then just put them on hold and then discuss them later. Otherwise, we'll not be able to complete this in the rest 10, 12 minutes that we have. So starting from the most recent question that I have received, this is from Arunji. If claim is outstanding in books but not claimed by authorities, can it be rejected if it is belated? So as we said that if now we are the legal position presently is that if the claim is outstanding in the books and the person has not filed their claim, you incorporate that in the IM, and even if the claim comes in at a belated date, then you're protected, or the RA is protected because the claim is addressed in the IM. That's my idea there.
No, I
Anything
think
to?
this is right. It's absolutely right.
So then we
Absolutely.
have anonymous attendee filing in the claim of joint developers and landowners and real estate companies. I think your question is not related to the claim verification process, but with respect to the status of these people as
I,
operational
no, I
creditors or
think we
financial
can.
Creditors.
I think we can reply this because
Mhm.
this is our subject. Uh, I think as far as this claim of land owning agencies are concerned, let us take first of all the case of land owning agencies, where they give land on lease to builders like Noida or Greater Noida authorities. So the Supreme Court has held in the case of Anand Sonbadra versus Noida. This is the case which is fought by AAA Insolvency. Anand Sonbadra is our partner. So in this judgment, the Supreme Court has held that the kind of terms and conditions of the lease executed by the land owning agencies with the builder, it shows that it is an operational lease. Therefore, their claim would only be considered as an operational claim. So they would be operational creditor. That's what is the status of the land owning agencies where the land is given on lease. Now there is a second scenario is where the land is owned by some private person, and the private person enters into a joint development agreement with the builder, and the builder company goes into insolvency. So what is the status of the land owner? So we have an unclad judgment where it has been held that the land owners, when they enter into joint development agreement with a builder company, they would be considered as promoters. They would not be considered as a creditor of the company. So their claim is not admittable because they are kind of a joint promoter of a project where they have some uh, obligations. They have land, and the builder has take up the construction work, and the possession has only been given for the purpose of construction. The builder has invested on the land owned by the landowners. The ownership of the land still continues to be with the landowners. So NCLAT says that they are not a creditor and they are the joint venture partners, so they are promoters. So this is the answer for this question.
So let's move on. Next question is, so there is a question from Mr. Veer Pandian. He says how to deal with the support services that is necessitated to engage to complete the claim verification process. So we have a disciplinary order on this. We will discuss this topic at length when we discuss that issue. It very clearly differentiates between what can be outsourced by the RP during the claim verification process and what cannot be outsourced. So that's very important, that the responsibility cannot be outsourced, but the whole background work with respect to processing the claims can be. That's the basic idea behind the answer to this question.
Yes, you're right. I think we will read that IBBI order, where the outsourcing is something which is considered to be not acceptable. Any other question?
Then we have whether claim received barred by limitation where no transaction with party in last 3 years, though appearing in the books of accounts. So there are 2-3 judgments with respect to limitation which say that in case the CD's books of accounts confirm that there is a liability, then limitation may not apply. Number 2, it all depends on the factual case. In case there is any way in which the debt has been acknowledged or is already disputed in a court, then the limitation again of 3 years would not apply. But where there is absolute silence and there is no communication, no acknowledgement, no follow-up from that party for a long time, there that limitation will apply. But as we said, the RP is not supposed to adjudicate the limitation applicability. And if there is a dispute on the applicability of limitation, then the claim needs to be admitted along with that dispute. You can further add in case you have something to add to this.
No, I think there are, when it comes to limitation, the limitations are applied in both manners. One is when this application is submitted to adjudicating authority for initiating CIRP. One, the limitation is applicable, and secondly, when a claim is filed before the RP or IRP, whether the RP or IRP will apply jurisdiction law or not, this is something which is presently not clear, because see, I understand that this applying limitation law would also tantamount to adjudication. In case somebody, because see, then that actually means that in case you would reject, then the other person will submit something which is assumptions like balance sheet and like payment, and then when the renewal of the limitation period, so that actually becomes a matter of adjudication. So in case of limitation, I believe that the RP should reject the claim, saying that it is barred by limitation, and let this be adjudicated by the adjudicating authority. This is what is my understanding. But yes, one thing is very clear: while admitting or rejecting the claims, the RP can apply limitation law.
Okay. The next question is from Mr. Rajan Rawat. He says that the claims of operational creditors filed and admitted during CIRP process. However, after liquidation orders, the same operational creditors filed their claim after the last date as per the public announcement. Should the liquidator reject the claim? I think we will come to the liquidation related claim processes and discuss this.
Yes, I think the couple of judgments that we have now after the approval of resolution plan, that you can take up these judgments, because see, we should finish this the claim uh, scenario where the resolution plan has been approved by adjudicating authority. So there are a couple of
So,
judgments.
so
Will
let's
let us
complete these judgments, and
yeah,
then maybe in case time permits, then we can
you
take
can
some
take
more
up
questions. Yeah.
these judgments.
So after this one is Akshar Plaschem Investment Private Limited versus Sri Vijay Murmuria RP of Kitfly Industries. Here the facts were that the appellant submitted that he has been carrying its business in the state of Maharashtra, more particularly in district Nashik, and then the corporate data conducted material businesses in the state of Maharashtra. Hence, publication ought to have been made in the state of Maharashtra. But due to non-publication or public notice, the place where applicant was carrying on its business, no claim could be filed by the applicant before the IRP. So here it was held that the statutory requirement of publishing public announcement cannot be stretched to mean that publication has to be made from all places where the CD is receiving goods and supplies. The mandatory requirement is to publish it one English and one regional newspaper with wide circulation at the location of the registered and corporate office of the corporate debtor and any other location where, in the opinion of the IRP, the corporate debtor conducts material business operation. So it is basically, it says that it is discretion of the RP. You can't just have a public announcement floating around every state. After, then this one, the last date for receiving the claim was this date, and the applicant filed a claim after 20 months from the last date of receiving the claim. So relying on the judgment of Honorable Supreme Court in Ghanshyam Mishra and Sons Private Limited, it was held that on the date of approval of RP resolution plan by the authorized adjudicating authority, all claims which are not part of res plan would stand extinguished, and there was compliance of regulation 6 2 and 3, and since the publication was uploaded on the website of the corporate debtor as well as the website of the board, there is no error in the publication made by the IRP under section 15 read with regulation 6(1) of 2016 regulations.
So these
So
are
no error
two
was there.
judgments, Ankit, where the claimants who could not file their claim within the stipulated period, they somehow took the argument that the publication was not correct. It was supposed to be published in their state also. However, both got rejections from adjudicating authorities and appellate authority. Reason being that then it is important that the mandatory clauses are complied, and the RP cannot be expected to uh, publish these notices everywhere, wherever the business of the company is being held. So
Yeah.
these are both court rejected.
Then there's this case which is Diwan Housing Finance Corporation versus Nihal Mahamulal Pathan. This is here it was held by NCLT Mumbai in February 22, again a recent judgment. But the code expressly mandatory requires the claim has to be filed, and a claim is not filed, the claim is lost by acquiescence not filing of claims, and the applicant, being a secured creditor, has failed to file his claim before the resolution professional after initiation of CIRP of the CD. This bench has no hesitation to conclude that the object of the secured creditor is an objection of the secured creditor is untenable.
So again, it was rejected. Belated
Yeah.
filing of the claim was rejected because the resolution plan has already been approved.
Basically, the courts have to say this, that in case the whole process has been completed and you suddenly wake up being a creditor and realize that, oh, my claim was also there in this company and this company made some distribution to other people, everyone else got money, I did not get money. You can't just wake up at that time without any solid reason for that.
So
Pecan
the next,
developer.
so this case is basically, Ankit, our case, Pecan Developers Private Limited versus Bimal Agarwal, RP of DagCon. Bimal Agarwal is a partner of AAA Insolvency based out of Kolkata. And this is the NCLAT judgment that we fought. In fact, NCLT has directed us to accept this claim belatedly. However, NCLAT has said that it is directing to accept the claim is unfair to the other creditors who could not file their claim with the RP because of the delay, but would also dilute the purpose of the publication of Form A, because in case the adjudicating authority will keep directing all the RPs to accept claim, then the publication of Form A would also be diluted, and this is not fair. So the NCLAT said that yes, it is not always required that we should direct the RP to accept. Again, this is Municipal Corporation Faridabad versus Sajeev Bhushan Deora, and again NCLAT judgment in December 21. And they see basically again two prayers which were made by the appellant are with regard to the directions to the liquidator to accept claim of the municipal corporation and further directions to the liquidator to conduct fresh valuation. So in this case, NCLAT said that the prayer made in the application could not have been granted as there is no claim filed before the liquidator or even before the resolution professional by the appellant. The claim at the stage when it was filed could not have been accepted and was rightly rejected by the adjudicating authority. Sale have been complete at this stage. There is no occasion to entertain the claim. So this is a case of liquidation where even the assets were sold and the Municipal Corporation of Faridabad filed their claim even after the asset was sold. So therefore, the NCLAT even rejected that. NCLAT even rejected that. I think we should not take it beyond 1 hour. And since we have to take up part 2 and part 3, because this is a very large issue. Now we actually have, we've finished that because we are the, after the approval of the resolution plans, and now we are now on a new subject, which is a maturity of claim. So from this, we will actually conduct our part 2 next Sunday at 1 p.m. All coming judgments, because we have a plethora of judgments on claim verification, and we have only reached so far slide number 27, and we have total slides which are 66. And the most important subjects also would actually be it will be in the following slides, like the disciplinary orders and also the proposed changes. That also will be handled by Ankit, maybe in part 2 of this subject, that is the verification of claims. I think for this it is over, because we have completed, like, before the approval of the resolution plan and after the approval of the resolution plans, we have completed the definitions, and we have kind of explained today how this stage of the process is important, how the stage of the liquidation process is important, how it is important for when the class of claimant is also important. So all this we are trying to explain. So Ankit, if there is any important question that we can take up, and otherwise I think we
rather, there are many questions. There are about 30 questions, but I think we should not extend our discussion to those questions, because majority of the topic is yet pending for discussion, and a lot of questions will be answered through those discussions. So let's continue this next week, all our participants, and then we will take it further.
So we will note down these questions, and we will it will not be required to again write the questions. Important subjects, and similarly the participation is very, very encouraging. Thank you very much, participants. And as we collectively say that it is our collective learning process, and this is a way that we learn. Thank you very much, participants.
Thank you, everyone. Thank you.